Thank you, Vikasji, and I hope I'm audible. I hope I'm clear to all of you, and very good evening to all of you, and welcome you all. Uh, this is my second session with law advocates, and I'm very happy to have collaborated with them. The first session that we covered was on the criminal law journey from the institution of an FIR. So, in case any of you are interested, you may kindly go back to that session because we've covered the entire gamut in the criminal law journey there. Today, we will be speaking on the law of bails. Now, since we will be covering various aspects of the code, we will be looking at various provisions of the code. I'm afraid the session could be slightly academic, but since I understand that there are largely students and judicial aspirants attending this webinar, uh, I will of course give them what the law is, what the various provisions of the code say as far as bail is concerned, and I will also try and give examples of the various Supreme Court judgments that have happened so far and that are considered landmark judgments in the law of bail. So, some people are saying that there is a sound issue. Uh, I hope I'm clear, Vikasji. I'm getting some chats that there are some sound issues and there are some buffering issues. Anyways,
Your voice is audible, sir. Your voice is audible.
all right, the voice is audible, no? All right, thank you. Okay, so we start straight away with the chapter on bails. Now, chapter 33 of the CRPC Code 1973 talks of the various provisions of bails. Chapter 33 starts with section 436 and goes right up till section 450. We'll try and have a cursory look at these provisions. In this discussion, we will be looking at various things, as in cases where the grant of bail is a matter of right. We will be looking at non-bailable offences where the power of grant of bail is discretionary. We will be looking at the provisions of anticipatory bail, and we will also be looking at, if time permits, bails with regards to special laws in the country, where typically the CRPC doesn't hold good. So we'll try and have a look at all these provisions, and we will also have a look at the various Supreme Court judgments just so as to refine our understanding. As I said, chapter 33 of the code talks about the various provisions relating to bails, bonds, and sureties. It starts with section 436. And I'd request some of the participants, if they can have a handy criminal manual book with them, it will always be good for them to refer to the provisions. Let us first try and understand conceptually, what do we understand by the term bail? You see, typically in the code, the bail term has not been defined. Like so many other terms, like FIR, bail also has not been defined in the code. The term bail is derived from the French word baillier, Baillier, which means to give or to deliver or to hand over. To put it very simply, bail basically is a process of setting a person at liberty who has been arrested or detained by obtaining his security. The security can be in the form of bail bonds, or the security can be in the form of sureties, or both, so as to ensure that the person who's being released on a bail appears for trial. Okay, that is the plain and simple understanding of the definition of bail. It is basically to set a person at liberty who is undergoing a trial. You see, the object of bail has to be understood in the context of Article 21 of the Constitution of India, which speaks of the right to life and personal liberty. And I needless add, for those of you who know, that Article 21 is perhaps one of the most pregnant fundamental rights in the entire chapter of fundamental rights, because it has constantly been interpreted by the honorable courts, and the notion of Article 21 has always widened. So, against uh, the notion of liberty as enshrined in Article 21 and the presumption of innocence, which is one of the cardinal principles of criminal law, the entire provision of bail is secured. Now, there are various definitions of bail. I'll just read it for the sake of clarity. The Wharton Law Lexicon defines a bail as: a bail means to set at liberty a person who is arrested or imprisoned on security being taken for his appearance. So, very simply put, it is a process of securing the liberty of an individual. What is very important to understand, especially for legal students and legal aspirants, is that bail merely means the granting of bail merely means the change in custody. It means that the person who has been granted bail has not been acquitted, but he has been brought in the constructive custody of the court. Okay, he has been brought in the constructive custody of the court. And therefore, whenever a bail is granted, many conditions are put forth. And it is expected that the person who is released on bail will comply with those conditions so as to ensure his appearance during the entire process of trial. Okay, so that is the broad understanding of the concept of bail. And we will now be looking at some of the broad principles, some of the broad principles on which the concept of bail is based on. The first is that in cases of bailable offenses, bail can be asked as a matter of right. Secondly, the second important principle is in cases of non-bailable offenses, the grant of bail is discretionary. Therefore, while the grant of bail in cases of bailable offenses is a matter of right, and the person arrested can pretty much ask for it as it is his right, in cases of non-bailable offenses, these powers to grant bail are discretionary. We'll look at both these categories in some time. The third important principle is that ordinarily a bail shall not be granted by a magistrate if an offense is punishable with either death or imprisonment for life until and unless the accused is a woman or a minor under 16 years of age or a sick or an infirm person. So, save and except these exceptions, the magistrate does not have the competence in granting bail, especially for offenses where the punishment is death or imprisonment for life. The fourth important principle is that the court of session, that is the session, you see, in criminal law, there are a hierarchy of courts, starting with the Supreme Court being the apex body, and then you have the high courts, then you have the district courts and the session courts. So the court of session and the high courts have very wide discretionary power, which we will see when we are discussing section 439 of the code. But so far now, let us keep these four broad principles in mind. We will now be looking at the first category, that is, when is the grant of bail a matter of right? Uh, Initially, this discussion will be slightly academic because I will be looking at certain provisions of the code. And then, of course, we will discuss various judgments of the Supreme Court and the Honorable High Courts so that there can be absolute clarity. But in case any of you want me to explain it again with the help of Vikasji, I can, if the same is conveyed to me, I will certainly try and explain it again to you. As I was saying, the first category we will try and understand where the grant of bail can be asked as a matter of right. Okay, and within that first category, the first of such case where the grant of bail is absolutely granted as a matter of right is in the case of bailable offenses. This I'm sure all of you would know it. What is a bailable offense? A bailable offense, as defined in section 2A of the code, are those offences which are shown as bailable in the first schedule of the code. Therefore, in the CRPC manual, if you look at, if you go right at the behind of the book, you will have a look at the first schedule. Now, the first schedule gives you an understanding of the various classification of offences, and against each offences are mentioned whether that particular offence is a cognizable offence or a non-cognizable offence, whether the offence is triable by a court of magistrate or a sessions court. And similarly, it is mentioned in that schedule whether that particular offence is a bailable or a non-bailable offence. So that is where you will understand whether that offence, by looking at that schedule, you can understand whether that offence is a bailable or a non-bailable offence. Uh, just for sake of better understanding, the basic difference between bailable and non-bailable offences are that a bailable offence are less serious in nature as compared to non-bailable offences. Okay, so generally offences with imprisonment up to 3 years can be categorized as bailable offences, with exceptions, of course, and those offences over and above 3 years of imprisonment are non-bailable. So the basic difference between a bailable and a non-bailable offence is that bailable offences are not as serious as non-bailable offences. So when we look at 436, the first section with which the chapter on bails, chapter 33, starts, is we look at in what cases bail is to be taken. So we said the first case is a bailable offense. Now, please remember this section, section 436, is an imperative section, and the magistrate is bound to release a person charged with a bailable offense on bail. All right. So this is the first category of offense. The first category, that is where the grant of bail is can be given as a matter of right, is in the case of bailable offenses. Now, although the power to grant of bail under bailable offenses is not discretionary and it has to be granted as a matter of right, please remember the Supreme Court has held that if after the granting of bail, even in bailable offences, if the conduct of the accused who has been released on bail is found to be prejudicial to trial, or if he is seen not to be complying with the conditions of the bail, then that bail that has been granted to that accused can be cancelled. The bail bonds that he has furnished to the court can be forfeited and can be cancelled. So please remember that even in cases of bailable offences, though the grant of bail is a matter of right, these bails can be cancelled if the person who has been released on bail does not comply with the conditions of the bail given to him. Uh, let me ask a question now, since we are discussing on bailable offences. Suppose an FIR is registered, and based on the FIR, the police arrests an accused for bailable offences, and the accused then is released on bail. But subsequently, a second FIR is lodged again. A first FIR is lodged, a person is arrested, but he is subsequently released on bail. What happens if a second FIR relating to certain additional charges are filed? Will the person who has been released on bail be required to again uh, ask for bail, or the initial bail order that has been granted to him would be sufficient? Okay, the answer to that is, if an accused is granted bail arising out of an initial FIR and again an FIR, a second FIR is registered with certain additional charges, in that case, the accused will be directed to surrender again, and he must apply for bail in respect of those additional charges. I will repeat, the accused would be directed to surrender, and he will then have to again apply for a bail in respect of those additional charges which was not part of the first FIR. Please keep these things in mind, since this is a rather legal discussion. It could be expected from students to have these small, minute points in mind. Similarly, when an accused is granted bail by the police, the magistrate subsequently has no power, he does not have the jurisdiction to order for fresh bail bonds. Okay? When an accused is released on bail by the police, the magistrate does not have the jurisdiction to order for fresh bail bonds. So, this is the first condition wherein the grant of bail can be asked as a matter of right. The second category, which has been explained in the CRPC code, is in cases of statutory bail, or also what is known as the default bail. You see, section 167, provision 2 of the code speaks of a provision where a person has been arrested and he has been in custody, but the investigation has not been completed and the police has been unable to file the charge sheet within the prescribed period of 90 or 60 days, as the case may be. If upon the expiry of such period, that is 90 or 60 days, the investigation is not completed, the person has been arrested and is kept in custody. In such a case, upon the expiry of the 90 or the 60 days, the person who has been kept in custody or is arrested can ask for what is known as the statutory bail. Okay? Please remember, the power of granting statutory bail as under section 167 provision 2 of the code is an absolute right. So apart from bailable offences, this is the second category, a category of statutory bail wherein a bail necessarily will have to be granted to those arrested in case the investigation has not been completed within the prescribed time. There is another section which has been inserted by the Amendment Act of the year 2005, which is section 436A. I'd request some students, those who have the manual copy in with them, they can have a look at section 436A. Section 436A, which has been inserted by the amendment of the year 2005, mandates that an under trial prisoner other than one accused for an offence punishable with death shall be released on bail if he has been in detention for a period extending up to one half of the maximum period of imprisonment specified for that offence. Therefore, what simply section 436A says is, you see, earlier it was being seen that a lot of under trial prisoners were being kept incarcerated, jailed for a period even longer than the punishment prescribed for that offense. Therefore, keeping that in mind, section 436A was inserted, and it basically means that if an under trial prisoner has already led has already been in custody for a maximum period of half of the punishment prescribed for that offense, then under section 436A, he can be released on bail. This is a newly inserted provision. Another extremely important category for you to understand is section 437. You see, section 437 basically speaks of granting of bail in cases of non-bailable offences. We will come to that a little later, but I'd request all of you to look at section 437, provision 2 of the code. It says, if it appears to such officer or court that at any stage of the investigation, inquiry or trial, as the case may be, there are no reasonable grounds for believing that the accused has committed a non-bailable offence, but there are sufficient grounds for further inquiry into his guilt, and pending such inquiry, he shall be released on bail or at the discretion of such officer or court on the execution by him of a bond with sureties for his appearance as hereinafter provided. So, Section 437, Provision 2, speaks of a case where during the process of investigation, inquiry, or trial, if it can be reasonably concluded that there is still sufficient grounds for his inquiry into his guilt, the accused may be released on bail. This is a very, very important uh, section 437, Provision 2, but very often missed when we are discussing the chapter on bails. Apart from these categories, there is also the section of section 437(6) and 437 Proviso 7. You see, section 437 Proviso 6 speaks of a case where a trial has not been completed within a prescribed period. In case a trial has not been completed within a prescribed period, that is 437 Proviso 6 of the Code, and I will just read it. If in any case triable by the magistrate, the trial of a person accused of any non-bailable offence is not completed within a period of 60 days from the first date fixed for taking evidence, then such person, if he is in the custody during the whole of the said period, shall be released on bail to the satisfaction of the magistrate. So this is again for the purposes of expediting the trial so that the trial does not go on endlessly. There is yet another category, and the last category in the first that we're discussing, that is section 437 Proviso 7. I'd request all of you who are attending this webinar to just jot down these sections on a notebook, and then at leisure you can go look at it in detail. 437 Proviso 7 speaks of, if at any time after the conclusion of the trial of a person accused of a non-bailable offence and before the judgment is delivered, the court is of the opinion that there are reasonable grounds for believing that the accused is not guilty of any such offence, it shall release the accused if he is on custody on the execution by him of a bond without sureties for his appearance to hear judgment delivered. Now, this, of course, has never been used, at least in my years of practice. I've never seen a court granting bail on the basis of 437 Provision 7. But since it is there, I thought I might as well explain it to you. So these are the categories in which the grant of bail is not discretionary, but the grant of bail becomes a mandate as prescribed under law. The various categories that we have seen are the categories of bailable offences. In cases of bailable offences, the grant of bail is a matter of right. In cases of statutory bail or default bail, as we have seen under section 167 Proviso 2 of the Code. Similarly, there are other sections such as section 436A, 437 Proviso 2, 437 Provision 6, and 437 Provision 7, where the grant of bail is not discretionary but is under the mandate of law. Now, having discussed the first category, we will now look at those categories of offences where the grant of bail is not mandatory but is in fact discretionary on part of uh, the court granting it. Okay, so we have completed section 436, and we will now come to section 437. You see, a naked perusal of section 437 says, when bail may be taken in cases of non-bailable offences. So section 437 basically speaks of all those says that in cases of non-bailable offences, the grant of bail is discretionary. And all that you will study in section 437, the various provisos and subsections in it are basically limitations and conditions which have been imposed, which must be kept by a court while granting bail. I will not go too much into the details of it. Uh, all right. So, Section 437 basically talks of uh, the discretionary powers of the court subject to certain limitations. In cases of non bailable offences, the power to grant bail is discretionary. Now, when I say that the power to grant bail is discretionary, I mean they are not mandatory, but they're certainly not arbitrary. And the Supreme Court, time and again, has given many, many judgments wherein they have imposed conditions which must be kept in mind by the court granting bail. One such important judgment, and there'll be many more judgments, but for the time being, there is an important judgment which is by the name of Aish Muhammad versus Shivraj Singh. Aish Muhammad versus Shivraj Singh. It has been reported in 2012, Volume 9, Supreme Court Cases, page 446. Now, in this case of Aish Muhammad versus Shivraj Singh, reported in 2012, Volume 9, SCC, page 446, the various conditions for grant of bail has been explained. Of course, I will be giving to you many, many more judgments. But as I said earlier, that the grant of bail, although discretionary, is based on a number of considerations. A number of considerations. Some of these considerations, I will just read it out to you. The nature and gravity of the offense, the enormity of the charge, the severity of the punishment prescribed, the manner in which the offense is committed, the involvement of the accused in other cases. Now, this is a very important consideration. You see, whenever we're filing a regular bail application in the High Court, there is in fact a mandatory paragraph wherein we have to mention whether the petitioner has a criminal antecedents or not. It is almost mandatory to mention in all bail applications regarding the criminal antecedents of the petitioner, whether the petitioner who is applying for a bail has been granted bail in other cases, or whether he has been a habitual offender, or whether he has been charged with other offenses in other cases. So, depending on these considerations, these are only illustrative conditions, these are not exhaustive conditions. The grant of bail is discretionary, looking at many, many facets. Now, apart from granting of bail as a matter of right in cases of bailable offences, as we have seen in section 436, and grant of bail, which is discretionary, as we have seen in section 437, there are also certain categories mentioned in the code where the bail can be granted. And I will just request some of the readers to note it down. Section 389. Section 389 grants the appellate court to grant bail to a convicted person during the pendency of an appeal. Therefore, when a person who has been convicted, he will naturally file an appeal before the higher court, the appellate court. During the pendency of such appeal, under section 389, the appellate court has the discretionary powers of granting bail. The second such section is section 397 to section 401. Under these relevant sections, the bail again may be granted to the appellant who has asked the revisional court for a criminal revision. You see, just as the remedy of a criminal appeal, there is also in the court the remedy of filing a criminal revision. In case an order is final and revisable, the person who has been convicted has a remedy of challenging that order in the subsequent appellate court. In that case also, the revisional court listening to the criminal revision petition can grant bail. And the third is under section 395. Under section 395, when the lower court makes a reference to the high court on some substantial question of law, in that case too, the higher courts have the exclusive powers of granting bail. Therefore, what are the three sections that we have studied? Section 389, that is during the pendency of appeal. Section 397 to section 401, that is during the pendency of the criminal revision. And section 395, when a reference is made by the subordinate court to the high court involving a substantial question of law. Having discussed section 436 and section 437, we will now come to, all right, I can also have a look at the comments, and I think most of you are with me and I think I'm understandable. I will now go on to the next section, which is section 438. Section 438 is a rather newly inserted provision. It speaks of the provisions of anticipatory bail. Earlier, in fact, in the code, section 438 was just one liner, but after a subsequent amendment, I think the amendment of 2005 or 2008, the whole provision of anticipatory bail has been expounded. Okay, so we will now be looking at section 438, and we do know that this is an extremely important section. You know, sometimes section 400, the anticipatory bail petitions filed under section 438 is much more than the regular bail petitions. Okay, so section 438 deals with the provisions relating to anticipatory bail. Now, again, just like the word bail has not been defined in the court, similarly, the word anticipatory bail has also not been defined in the court. Anticipatory bail, simply put, means bail in anticipation of arrest. Bail in anticipation of arrest. When a court grants anticipatory bail, it makes an order that in the event of an arrest, a person shall be released on bail. Please remember, often these are questions that have been asked by me, that for the order of anticipatory bail to become effective, is the arrest of the accused necessary? Yes, the answer to that is absolutely. There is no question of release on bail unless a person is arrested. And therefore, it is only upon arrest that the order granting anticipatory bail becomes operative. This is very, very important, and I'm paying emphasis on this aspect, that there is no question of release of a person on anticipatory bail unless a person is arrested, and therefore it is only subsequent to, upon the arrest of an accused, that the order granting anticipatory bail becomes operative. Okay, so yes, the arrest is very important. Only then can the order of anticipatory bail can become operative. Now please remember, the powers of the court to grant anticipatory bail under section 438 is extraordinary in nature. It is extraordinary in character, and it is only in exceptional circumstances. It is only on exceptional circumstances where it appears that perhaps a person has been falsely implicated, or a frivolous case has been launched against that person with the intent of malafide, or only for the purposes of a vendetta, or for tarnishing image. Can such a person apply for an anticipatory bail when there are reasonable suspicions? Okay, therefore, who is applying for an anticipatory bail a sudden that he is likely to be arrested. Okay. Okay. So, as I said, anticipatory bail is an extraordinary remedy and it can only be granted in exceptional circumstances. Please remember that the provision of section 438 is only applicable in cases of non-offenses, not applicable in cases of bailable offenses. Okay. Okay. Again, one important question that is often asked to me is the filing of an FIR necessary for me to ask for an anticipatory bail? Therefore, in other words, the question put differently is, does my name need to appear in an FIR for me to file an anticipatory bail? The answer to that is no. Filing of an FIR is not a condition precedent to the exercising of powers under section 438. Therefore, even in the absence of a FIR, the power of granting anticipatory bail by the court can be exercised. I will repeat, even in the case of an absence of an explicit FIR, the provisions, the powers under section 438 can be exercised. Whenever you are looking at the topic of anticipatory bail, one landmark judgment to the Supreme Court that comes to play every time as a lawyer, every time I have filed an anticipatory bail petition, I have always referred to this judgment, and I would request all the hearing members to kindly note down this judgment.
Excuse me, sir. Sir, can you hear me?
Yes, yes, Vikasji. I can
Sir,
hear
your
you.
voice is breaking. Sir, your voice is not audible. Your voice is breaking in between. So
Okay,
let
I
me
don't know
add you once
what can be
again.
done about that. Yes,
So wait
please
for a
add me
second.
again.
I will add you once again. Wait for a second. Yes, sir. Now your voice is audible.
Is the voice
You can
audible
start
now?
the session, sir. Again.
Okay.
Yes, sir. Yes.
I'm extremely okay. I'm extremely sorry for the disturbance. So I was discussing, Vikaji, I was discussing section 438. Could that be heard?
Yes, sir.
Okay. So as I was saying is, whenever a petition for section 438, that is a petition for grant of anticipatory bail is filed, we always refer to one important landmark judgment of the Supreme Court, and that is the judgment of Gurbaksh Singh Sibia versus State of Punjab. Gurbaksh Singh Sibia versus State of Punjab. Please note down the citation, 1980, Volume 2, SCC, Supreme Court Cases, page 565. This is an extremely important judgment so far as the aspect of anticipatory bails are concerned. Okay. There is another important judgment of the Supreme Court which basically discusses the various circumstances when an anticipatory bail can be granted. And I would request you to note it down again. Badresh Bipin Badresh Bipin versus State of Gujarat, 2016, Volume 1, SCC, page 152. Both these judgments are landmark judgments as far as uh, understanding the concept of anticipatory bails are concerned. So as we've discussed earlier, the powers under section 438 is extraordinary. It must be only granted in exceptional circumstances. The second is that the order of anticipatory bail becomes operative only upon arrest and not before. Thirdly, the filing of a charge sheet is not a condition precedent for filing of an anticipatory bail. We've also looked at two Supreme Court judgments that are pertinent for understanding this topic. Another important aspect relating to section 438 is that section 438 grants concurrent jurisdiction. That is, it gives the option to the accused to either apply to the court of session, or it gives the discretion to the accused to directly move the high court. Now, although under section 438, the power has been, the jurisdiction is that of a concurrent jurisdiction, ordinarily, it is the court of session which must be moved first. And in case the anticipatory bail petition is rejected by the court of session, then uh, the accused has the option, the liberty of then moving the high court. This is the general practice. Okay. Now, one important question with regards to anticipatory bail before we wind up the discussion on anticipatory bail is, can a successive anticipatory bail application be filed? The answer to that is yes. A successive anticipatory bail, that is a second anticipatory bail petition, would be maintainable if there are additional facts, certain further developments, or certain new considerations. In fact, when you are discussing either the aspect of successive bail applications or successive anticipatory bail applications, the second bail or anticipatory bail application petition will be maintainable if there are some new developments in the case. Maybe the charge sheet has been filed, or certain new considerations which was not discussed initially. If those new conditions have arisen in the case, then a successive bail or an anticipatory bail petition would be maintainable. The underlying theme here is certain new developments, certain other reasons must have arisen for the second anticipatory or the second bail application to be maintainable. Okay, and also in the legal parlance, the general practice is the court that has first granted or refused the bail, and you file a second bail application or a second anticipatory bail application, the same petition must be heard by the same court that had heard the bail in the first time. This is generally the practice until unless the court is not available or the judge has retired. Otherwise, in all circumstances, the successive bail applications must be filed before the same court. Okay. Now, having discussed section 436, having discussed the various other sections where the grant of bail becomes a mandate, having discussed section 437 and 437A, also discussing the fact that the powers of grant of bail under non-bailable offences are discretionary, having discussed with you section 438, that is a provision dealing with anticipatory bail, we now come to another important aspect, which is cancellation of bail. Please remember, cancellation of bail is very different from rejection of bail. Okay? You see, when you apply for a bail and that bail has been rejected on merits, that and another condition where you have been granted bail and that order of bail is being challenged in the higher court, both these conditions are very, very different. Okay, so the cancellation of bail is very different, very distinct from the rejection of bail. This is the first important point that you must keep in mind. Section 437 Proviso 5 empowers the court which has granted bail to cancel it if it considers necessary. Okay, section 437 Proviso 5 empowers the court which has granted bail to cancel it as if the conditions so speak. Similarly, section 439 Proviso 2 authorizes the High Court or the Court of Session to cancel the bail that has been granted to the accused. Okay. So please remember, whenever a bail has been granted to you and somebody else is aggrieved by that order of bail, he will challenge that order of bail in the higher court. And the session court and the high courts have wide discretionary powers under section 439 to cancel the bail. Of course, cancellation of bail also is dependent on certain considerations. It is not an absolute arbitrary power of the court. On certain fixed parameters, the court will consider whether the bail that has been granted to an accused should be cancelled or not. Okay, now we come to section 439. We've discussed 436, we've discussed 437, 438. Now we will be talking about section 439. You see, section 439 speaks of the special powers of the High Court and the Court of Session regarding bail. And all that you need to really understand as far as this section is concerned, that this section gives unfettered discretion, wide plenary discretionary powers both to the High Court and the Court of Session in granting of bail. Again, however, the grant of bail under section 439 by the Court of Session or the High Court is not uh, arbitrary, but it is based on certain judicial considerations. Okay. So all that you need to know as far as section 439 is concerned is that it gives wide discretionary powers to both the High Court and the Court of Session to grant bail. Okay. Now from section 440 to section 450, you will look, these are all provisions relating to bonds and sureties. So the entire provision from starting from section 440 right up to 450, that is where the chapter on bail ends, speaks of the provisions of bail bonds and sureties. Let us have a look at section 440. The amount of bond and reduction thereof. The amount of every bond executed under this chapter shall be fixed with due regard to the circumstances of the case and shall not be excessive. Okay, so section 440 says that the bail amount will not be excessive. And there are two important judgments, especially with regards to section 440, which I would request you to note it down. The first is an order of the Madras High Court, that is N. Sasikala versus Enforcement Officer, N. Sasikala versus Enforcement Officer, 1997, Volume 1, CTC, page 317. Here, in this case, the lower court had asked the petitioner to furnish a bail bond of 3 crores. Subsequently, that order was challenged before the High Court, before the Honorable Madras High Court, and the Madras High Court held that the bail amount that is so directed to the accused to furnish shall not be excessive. And it is in this regard that you must go through this judgment of N. Sasikala versus Enforcement Officer. The second important judgment in regards to section 440 is Husainara Khatun versus State of Bihar. Husainara Khatun versus State of Bihar, 1980, Volume 1, Supreme Court Cases, page 81. Okay. Both these cases are very, very important as far as section 440 is concerned. So, as I told you earlier, section 440 to section 450 deals with various provisions of bonds and sureties. I don't think so we need to go into the depths of that. I think we've broadly covered the academic part of this session. that is trying to understand Section 436, the various other provisions where grant of bail is mandatory, Section 437, where grant of bail is discretionary, 438, Section 439, that confers wide discretionary powers to the High Court and the Court of Session, the discussion on cancellation of bails and how that is different from rejection of bails. Having discussed all of that in a nutshell, we will now come to discussing certain important judgments of the Supreme Court, which you will note it down. And these become almost imperative as students of law. It is important to go through these judgments. Most of these judgments will absolutely make your concept on bails and anticipatory bails crystal clear. The first important judgment that you should look at, apart from the ones that I've already mentioned, is Gudi Kanti Narasimha versus Public Prosecutor, High Court of Andhra Pradesh. Gudi Kanti Narasimhulla versus Public Prosecutor, High Court of Andhra Pradesh. 1978, Supreme Court cases, page 1, page 240. This is a beautifully given authored judgment of Justice V. Krishna Iyer, and I would request all students and lawyers to go through this judgment. And it speaks of personal liberty. It talks of Article 21, the presumption of innocence, and how uh, the grant of bail safeguards all of these. So this is an important judgment that you must go through. Another important judgment that you must look at is the judgment of, and when we are discussing these judgments, I will try and show you also that the Supreme Court, the Honorable Supreme Court in itself, has been a little inconsistent in laying down the law. As I said, the grant of bail for non-bailable offences are discretionary. So at times the judgments of the Supreme Court have differed. The first judgment, apart from the judgment of Gudi Kanti, is the judgment of Pappu Yadav versus CBI. Pappu Yadav versus CBI. 2007, Volume 1, SCC, page 70. Pappu Yadav versus CBI. 2007, Volume 1, SCC, page 17. You see, in this case of Pappu Yadav, the appellant was charged with the conspiracy to murder his political rivals in broad daylight. And the court, both at the trial level and the appellate level, rejected as many as 10 bail applications of the appellant Pappu Yadav. And so this order was subsequently challenged before the Supreme Court. And the Supreme Court rejected the bail of the appellant despite the fact that all the prosecution had presented all its evidence and there was absolutely no possibility with tampering with evidence. You see, generally when a charge sheet is filed, generally when the investigation is completed, the courts are liberal to grant bail because they feel that now there is not too much of possibility of tampering with evidence. Once the prosecution evidence has been presented in the trial court, the courts are generally very liberal in granting bail because they feel that even if the person who will be granted on bail, he will not tamper with evidence or he will not abscond because now the investigation is completed and there is no question now of playing with the evidence, so to speak. But in this case, despite the investigation completed and the prosecution having presented all its witnesses, the Supreme Court declined the bail petition on the basis of the gravity of charge. It held that since the charges leveled against the appellant are so serious in nature that granting of bail, even if it is in the backdrop of Article 21, will not be the right thing to do. Okay, so this is an important judgment of Pappu Yadav versus CBI that you must go through. one of the most monumental judgments of the Supreme Court that has really sort of altered the jurisprudence of bail is the judgment of Sanjay Chandra versus CBI. The judgment of Sanjay Chandra versus CBI, which is also popularly known as the 2G case, 2012, Volume 1, Supreme Court Cases, SCC, page 40. Sanjay Chandra versus CBI, 2012, Volume 1, SCC, page 40. This again is a very, very important. If I could just request Vikasji, I've been getting some comments saying that the sound is a problem. I'd request if there's another device which is open, if somebody could close that device, maybe because of that there is some problem in the voice being communicated clearly. Vikasji, am I audible? Am I clear to everyone? Can everybody hear me without interruption? Hello? Hello?
Yes, sir. You are audible. Can you hear me, sir?
Hello? Yes, yes,
Can you
Vikasji.
hear
Is
me,
the
sir?
sound clear? I can hear
Yes,
you.
sir. You are audible. Can you hear me, sir?
Okay. Because I've been seeing in the comment section that some people are saying that there's some problem with the sound.
No, sir. In comment section also, the people are saying you are audible.
Okay, all right, okay. So the other judgment is that of Sanjay Chandra versus CBI, which is a 2G case. This again has taken very liberal view of bails, and this is an extremely important judgment. All of you must go through it. You see, in this case of Sanjay Chandra, there were allegations of large-scale corruption and collusion, and the Delhi High Court rejected initially the bail of the appellant, even though the investigation was complete. And the Honorable Delhi High Court in this case held that in cases of economic offences, which involves billions and billions of dollars, granting of bail may not be the right thing to do. This order of the Delhi High Court was subsequently challenged before the Honorable Supreme Court, and the Supreme Court granted bail to the accused in the year of 2011. In November 2011, this judgment came, and the judgment recognized that the right to life and personal liberty was the most basic of all fundamental rights. The court reversed the order of the Delhi High Court, taking cognizance of completion of investigation, and stated that the right to bail is not to be denied merely because the sentiment of the community is against the accused. So the Supreme Court went many miles in emphasizing on the right to life and personal liberty, and saying and reaffirming the earlier view taken by honorable judges like Justice Krishna Iyer, who had said that bail is the rule and jail is the exception. So in this 2G case also, the Supreme Court reaffirmed that proposition. The other important judgment is especially when you're speaking on the subject of bails and anticipatory, is that of V. Gowda, Virupakshappa Gowda versus State of Karnataka. I'll tell you why I'm talking about this judgment. Virupakshappa Gowda versus State of Karnataka, 2017, Volume 5, SCC, page 406. You see, post the Sanjay Chandra judgment, many bails were granted, even in cases of economic offences. However, in this judgment specifically, the judgment of Sanjay Chandra was relied on very heavily. The advocates arguing for the appellants were relying very heavily on the judgment of Sanjay Chandra. And the Supreme Court in this case, in the case of Virupakshappa Gowda versus State of Karnataka, rejected the bail application and said that the case of Sanjay Chandra cannot be made applicable in all cases. In fact, the Supreme Court, I think this is an authored judgment of Justice Honorable Justice Deepak Mishra. He says that the severity of the offense has to also be given due weight. Therefore, when the councils were relying heavily on the judgment of Sanjay Chandra, the Honorable Supreme Court distinguished this case from that of Sanjay Chandra and said that no, in cases where the offenses are very serious, due weightage has to be given to that. So you must, when you're studying the judgment of Sanjay Chandra, you must also have a look at the judgment, this particular judgment of Virupakshappa Gowda versus State of Karnataka. The other recent judgment, which again is very, very important, and of course all of you know about it, is the judgment of P. Chidambaram. As all of you would know, that Mr. P. Chidambaram, who is himself one of the most celebrated lawyers in the country, his bail was rejected. This is an anticipatory bail application. I'll first give you the citation. P. Chidambaram versus Directorate of Enforcement. P. Chidambaram versus Directorate of Enforcement. 2019, SCC Online, Supreme Court, page 1143. Okay. Now, in this case of P. Chidambaram versus Directorate of Enforcement, the Delhi High Court denied the bail to Mr. Chidambaram, saying on two considerations. Firstly, the gravity of the offense, and the Delhi High Court held that the appellant was being very evasive in his reply. And on these considerations, the Delhi High Court rejected the anticipatory bail of the appellant. This was subsequently challenged before the Supreme Court, and the Supreme Court also rejected this anticipatory bail, and it said that especially in matters of economic offenses, granting of anticipatory bail may not be the right thing to do, as it would hamper investigation. So you will see that the judgment of Virupaksha Gowda versus State of Karnataka and the judgment of P. Chidambaram versus Directorate of Enforcement is vastly different from the parameters that were set by the Honorable Supreme Court itself in the judgment of Sanjay Chandra versus CBI. Okay. So these are some of the important judgments that you must keep in mind when you're discussing bails. I have just missed one judgment, and all of you may note it down. You see, you will always be discussing the chapter on bails in the context of arrest. It is only when an accused is arrested that the concept of regular bails come into play. And therefore, to understand the concept of arrest, you may have a look at this judgment, which is the judgment of Social Action Forum for Manav Adhikar versus Union of India. Social Action Forum for Manav Adhikar versus Union of India, 2018, Volume 10, Supreme Court Cases, page 443. This is again a beautiful judgment which speaks on the entire jurisprudence of arrest. And so I would request all of you to go through these judgments to really make your concepts on bail and anticipatory bail and the powers of arrest crystal clear. I think we've almost finished the concept, the academic discussions on bail and anticipatory bails. I've also given out to you the various judgments, the various landmark judgments of the Supreme Court. Before I end, I will just take another 5 minutes. Vikash, is it all right if I can take another 5 minutes? I will just discuss the chapter of bails with regard to special laws in the country. If there is time permitting, I will just discuss that. Okay. You see, what we've studied so far is basically in context of CRPC, but also in this country, there are many special laws wherein typically the CRPC does not come into play. In fact, these special laws are codes in itself. They're law by themselves, and they prescribe their own procedure of trial, and they set out their own parameters. Some of these special laws are Prevention of Corruption Act 1988, the Narcotic Drugs and Psychotropic Substances Act NDPS 1985. The NDPS you've just seen yesterday, that the regular bail of Riya Chakrabarti has been rejected by the magisterial court, and now the bail is pending before the Court of Session. It is under this section of the NDPS. Just like the NDPS and Prevention of Corruption, there is also the Prevention of Money Laundering Acts 2002, Unlawful Assemblies Act. All these special laws, the typical liberal view that is taken by the courts do not operate in cases of special laws. You see, most of these special laws, like the Money Laundering Act or the Prevention of Corruption Act or the NDPS Act, any such, or the Makoka, the Maharashtra uh, Act, all these are special laws, and in all of these laws there are specific provisions with regards to bail, and the grant of bail under these special laws are much more difficult, much more stringent than as under the ordinary law. Okay, so just to give you an example, if you look at the NDPS Act 1985, you will look at section 37. Section 37 of the NDPS Act 1985 talks of the grant of bail, and it makes the grant of bail much more difficult. Therefore, when we are arguing bail petitions under special laws, we have to be all the more careful, we have to be all the more meticulous, because in such cases, the special courts are very reluctant to grant bails. So even despite the judgments of Sanjay Chandra and a host of other judgments where the Supreme Court has taken liberal views, under these special laws and special acts, the grant of bail becomes very difficult. So I just thought I'll very briefly touch upon this topic. This again is a very exhaustive session, so I will not go into the details of it. But I think that by and large covers the entire discussion on bails and anticipatory bails with the relevant judgments of the Supreme Court. Vikasji, if I could request you to come back and we can start the question and answer round.
All the attendees can post their questions, which will be taken up by the sir now.
In case there's any provision that students have not been able to hear or understand because of problems in sound, I can explain that again as per the convenience. Vikaji, are there any questions, or has everybody
No, sir.
understood?
I'm waiting
I
for the
think
questions only.
okay. Hota kya hai, just on a lighter note, sometimes when there are no questions, it could really mean two things. It could either mean that everybody has understood everything, or the second provision or the second aspect is that nobody has understood anything. I hope
That's it,
it's
sir.
not the second case.
So the first
Right.
question is,
Yes.
what is the remedy for the victim if charge sheet is tampered?
If the charge sheet is tampered,
Yes, sir.
so the remedy is then you invoke the powers under Section 482, which is the inherent jurisdiction of the High Court, and you bring out a case before the High Court saying that the charge sheet, the police has not been investigating the case properly in a proper and fair manner, and certain directions ought to be given to the police. So if the victim feels that the charge sheet is not being filed within a certain time frame, or that the investigation is not being done in a proper manner, the remedy would be to invoke the inherent jurisdictions of the High Court. 482.
Okay, sir. So the next question is, if a person is charged with four offenses, out of which three are bailable and fourth one is non-bailable, can the person claim bail as a matter of right?
No, no, because the fourth offense is a non-bailable offense. So for that particular offense, he will have to file a bail petition. In such a case, bail cannot be asked as a matter of right.
Okay, sir. Sir, the next question is, can we use the Sanjay Chandra judgment in MCOCA Act, that is Maharashtra Control of Organized Crime Act?
Uh, Absolutely, yes. The Makoka Maharashtra Control of Organized Crime Act, 1999. The Makoka is a very, very specific, special law that has been enacted by the Maharashtra Assembly. Of course, Sanjay Chandra's judgment is a general judgment, and you must rely on the judgment of Sanjay Chandra, because even in the case of Sanjay Chandra, the Supreme Court has granted bail in cases of economic offences. It is of course up to these special courts. See, for most of these special laws, there are special courts constituted. So, for instance, for prevention of corruption, there are CBI courts and not the regular session court that hears your bail application. They are generally very reluctant in granting bail. So you have to move the High Court eventually. And then it is discretionary for the High Court to grant you a bail or not. That depends on the particular facts and circumstances of the case.
So the next question is, can a person challenge the order of bail in a higher forum like an appeal?
Absolutely, absolutely, absolutely. All orders passed under Section 436, whether these are bailable offences or an anticipatory bail or a regular bail, if it is rejected by the magistrate court, you will challenge that order before the session court. If the regular bail is rejected by the session court, you will then move the high court. If the bail is again rejected by the high court, then you will finally move the Supreme Court. So all bails are appealable, absolutely.
So continuing to that question, what is the difference between challenging the order and a successive bail application?
Yeah. Challenging that bail order is basically cancellation of bail order. Okay, suppose an accused has been granted bail, then either the public prosecutor or the state government or the victim can assail that order that has granted bail in the higher court. And in that case, he will invoke the cancellation of bail. So, say a bail has been cancelled, a bail has been granted by the session court. The other side, that is the government or the public prosecutor, the state or the victim, has the option of challenging that order of bail in the high court. So that is cancellation of bail. Successive bail application means that uh, for your first set of offenses for which you have been charged, you have been granted a bail. Again, in a subsequent FIR, certain additional charges have been instituted against you. For those additional charges, you will have to necessarily file a successive bail application. So the successive bail application is absolutely maintainable if it is on new charges. So that is the difference.
So the next question is, if accused is sent to jail under 151 CRPC
Hmm.
and executive magistrate has refused the bail, what is the remedy? Where to file bail application?
Executive magistrate, you see, please remember, when you are looking at the powers of executive magistrate in granting bails, they are very, very restricted. I think the jurisdiction of an executive magistrate to grant bails is only for offenses which are punishable with a maximum of 3 month sentence or something. Uh, so, for an executive magistrate, you will then file an appeal before the court of session. But the executive magistrate has very, very limited powers. Only for very, very small offenses, the executive magistrate, like say the DM, has the powers of granting bail, not otherwise.
So the next question is, how to apply for bail in special law when the matter is pending before Supreme Court?
How to apply for bail when the matter is pending before the Supreme Court?
How to apply for bail in special law, maybe under special law. The person has not mentioned which special law he's talking about, when the matter is
Okay.
pending before the Supreme Court. So we will move on to.
Um, I'm not too sure of this question, but by the time a matter has traveled to the Supreme Court, in most of the times the accused will have ordinarily asked for a bail before the courts prescribed under the code. So, if the matter has finally traveled to the Supreme Court, in most cases the either the person would have been granted a bail or his bail would have been rejected.
So the next question is there any recent judgment to get bail in the matter of NDPS Act, where the accused was in possession of contraband more than commercial quantity?
Not that it can I can remember of any judgment, but perhaps if the bail of Riya Chakrabarti is declined by the session court and then she moves the high court, perhaps that could become a landmark judgment. I don't recall at the moment.
Okay, sir. So the next question is recent landmark judgments regarding bail that you have already mentioned in the
I've
session.
already talked about
Yeah.
uh, Chandra 2G case, P. Chidambaram. All these are important cases. Pappu Yadav versus CBI, that is one important judgment. Sanjay Chandra versus CBI, that is the other very important judgment. The third important judgment is Virupakshappa Gowda versus State of Karnataka. Then you have P. Chidambaram versus Directorate of Enforcement. And then you have a 1978 judgment, Gudi Kanti Narasimha versus State of Andhra Pradesh. These are some of the important judgments. As far as anticipatory bail is concerned, the judgment of Gurbaksh Singh Sibia is the most landmark judgment on anticipatory bail, and it's a beautiful constitution bench judgment. All of you must read that judgment of Gurbaksh Singh Sibia.
Mhm. So I guess that's all. There are no more questions from the attendees.
Thank you
So
so much.
with this, our question and answer round comes to an end. I would like to thank Advocate Anshuman Singh sir for such an informative session and for sparing time out of his busy schedule for this session. I have a small
Thank you.
announcement for all the attendees. Thank you, sir. That the link for downloading the e-certificates will be available on our website on 13th September 2020. With this, we wrap up this session. Thank you for joining this session. Stay safe. Thank you so much, sir,
Thank you.
once again.